Going to not take these in the order that they're indicated. By way of an update, I understand that the Subcommittee 2 tabled House Bill 416, so that will come off the agenda. Those of you who might have had an interest in that will not be considered. It did give a due pass recommendation to House Bill 653, which will stay on the agenda. Otherwise, we're going to begin with House Bill 185, which was heard very, very extensively yesterday in subcommittee and was given a due pass recommendation by the subcommittee number 1. And I recognize the Majority Whip, Representative Barry Fleming.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I appreciate you allowing me to come before you today and bring this bill. I want to start out by thanking Chairman Knox yesterday in the subcommittee, who allowed us to go on for at least 8 hours, it seems like, and was very gracious in allowing everybody to testify that wanted to speak. Mr. Chairman, the bill in front of you today, House Bill 185, is a bill dealing with the death penalty in Georgia. The bill does something fairly simple, albeit something that has maintained a lot of discussion recently. In Georgia right now, under our current law, in a death penalty case that's brought by a district attorney, a jury must decide 2 different decisions to apply the death penalty. The first decision is a 12-0 decision that this person indeed did commit the crime at hand. They also have to decide that it was an aggravating factor. In other words, that something was heinous about this, something different than, for lack of better terms, an ordinary murder. They can decide that in different stages, but at some point they have to make those 2 decisions. After they've decided that this was indeed the person who committed the murder at hand, they have to go back and make a separate decision, and that is about punishment. Should capital punishment, should the death penalty be applied in the case before them?
Do we need to stop and let somebody answer a phone?
The second decision under Georgia law currently is also a 12-0 decision. My bill would change that second portion of the case, and only that second portion of the case. It would not touch the 12-0 guilt-innocence decision, but it would affect the 12-0 decision dealing with whether or not the death penalty should be applied, and here's how it would work. It would change our law to be similar to those in other states, which allow a jury to give a recommendation to the judge. Right now, if it's 12-0 for the death penalty, the judge applies the death penalty under Georgia law. There is no decision there to be made. My bill would say that if it is 9-3, 10-2, or 11-1, the decision would then go to the judge, and he could decide whether or not in this particular case the facts were so egregious that the death penalty should be applied. Here is the problem that we're trying to solve in Georgia. There are numerous cases that we could tell you about, several that were heard in subcommittee, some of which you'll hear about today. I have something I'm going to show you in a minute about one of the cases. But the problem we're trying to resolve is allowing 1 juror or 2 jurors or 3 jurors to veto the will of the supermajority in a death penalty case. I say veto because they can absolutely stop anybody from making the decision to apply the death penalty under Georgia law if now one person votes against that. The case, as I said, there's numerous cases dealing with this. The case that has been most prevalent recently in discussions and gotten a lot of media attention was a case that happened back in 2005. The murder actually took place in 1999, but it happened back in 2005. The trial did in Gwinnett County. And you'll hear from the district attorney today who handled that case. You may also hear from some of the family members involved, and maybe even a juror. They were in the subcommittee yesterday. If not, we'll summarize their testimony for you. But there was a fellow named Harris, and he basically carjacked, kidnapped a young mother and her 2-year-old daughter, drove them up to Gwinnett County in an attempt to rob her and steal the car. He ended up killing the mother by shooting her several times, and also shot the 2-year-old little girl who was in the car seat and the back seat in the head and in the chest. This case was a death penalty case. The question of guilt was not in question. It was an easy slam dunk question on the question of guilt. The only question really to be decided in that case was the question of whether or not the death penalty should be applied. In that case, you had 2 jurors that held out. One juror absolutely refused even to debate the issue in the jury room, said, "I'm not even going to discuss it." The other juror set a standard whereby he said he needed to know the motive of the crime. He was here yesterday. He testified. Now, the motive was obvious. This was a robbery, taking two innocents' life for nothing other than a robbery, taking the car and taking what money she had. And the guy killed a child and a mother for that reason. And then, of course, to make it worse, he put their bodies in the trunk and he burned them. Now, you ask the question, should we allow two jurors who take those actions to stop the death penalty from being applied in Georgia? I say, no, we shouldn't, and that's what my bill would allow. In an instance like that, when you have two jurors, and here's an important part for you to remember, and you'll hear more about this in a little bit. Before you ever get on a death penalty jury, you have to go through a series of questions, some of which can last hours. Sometimes there are weeks that go on of defense lawyers and prosecutors questioning jurors. And you have to absolutely answer the question that you would be willing to apply Georgia law if the case were egregious enough and impose the death penalty. So this is not a question of where someone got on the jury and they were principally opposed to the death penalty from the start. If you're principally opposed to it or go in and say the opposite, that you'd apply it no matter what, you'll be excused and you won't be able to serve on the jury. These are people who said that they would go in and if the facts were heinous, that they would apply the death penalty. I'll tell you that you won't find many more cases where the facts were so heinous as this. So what my bill basically does, it attempts to remove the veto of 1, 2, or 3 jurors over a supermajority of the other jurors who think in the case that the death penalty should be applied. Let me tell you some things that the bill does not do, and I want to emphasize this to you. The bill does not change, as I mentioned earlier, the idea that 12 people unanimously have to decide that the individual on trial for murder was actually guilty, that they did it. My bill does not touch that. Early on, opponents of the bill were trying to confuse those two, but that was unsuccessful. It does not change the fact that you have to decide 12-0 for guilt. Another thing that it doesn't do, it doesn't throw into question the constitutionality of the death penalty. There was a tremendous amount of debate upon this yesterday. And the facts that I think are most prevalent is that other states currently have a system, not exactly like this, but similar enough, that death penalties have not been overturned because of a system where a supermajority recommends to a judge that the death penalty be imposed and the judge makes the decision. Another very important issue that has come up of recent, mostly in other cases, has been DNA testing. This bill will do nothing about changing the fact that we have DNA testing now. And the cases that you hear about that occurred many years beforehand, before we had DNA testing, with somebody who was later have shown probably not to have committed the crime because DNA testing showed otherwise. You won't have a murder case in the state of Georgia now where there's any question that DNA testing could shed light on the issue and it not be done. That won't happen in murder cases in the future in Georgia, so that's not an issue. The other thing I would say to you is that for a long time, when the legislature debated this bill previously, there was opponents would say, well, you know, we don't have a statewide public defender system in Georgia. We enacted that a couple of years ago. We're in the process right now working through some problems in that system. But the state of Georgia commits more money, by far millions more than it ever did before, to make sure that we have good lawyers to defend people when they have cases nowadays. Those are some of the red herrings that have been thrown up previously, but I think are very easily knocked down. The question before you today is, could there ever be a case out there where a situation where you would have less than a unanimous jury to decide that someone did indeed need the death penalty and make that recommendation to the judge? What I want to show you right now is a case that occurred down on the coast. This is a situation where a death penalty was sought, and I'm going to show you the evidence that the jury saw and the evidence that one juror saw when they decided they would not apply the death penalty. I'm going to let Steve Kelly, district attorney from the Brunswick area. Is that the circuit, the Brunswick circuit?
Brunswick circuit.
He's going to put the sound up to this microphone where you can hear it. The screen is small. Mr. Chairman, if you ever might want to stand behind you, face it towards you, and let them see the evidence of the particular case.
We'll turn up the volume on this mic.
Those of you who want to come around.
There you go. Ready, Mr. Chairman?
Okay, everybody around.
How you doing? Come on out. Come on over here. You got your driver's license? Where's your license at? Hold up. Hold up now.
It's on, I think. It just didn't pick up.
How you doing? Come on out. Come on over here. You got your driver's license? Where's your license at? Hold up. Hold up now.
Members of the committee, you've just seen what is irrefutable evidence of someone committing a crime. And to kill an officer of the law just for a traffic stop. Now, when that went to the jury, there was one juror that said that that wasn't good enough to impose the death penalty. And my point to you of this whole bill is, whether it be two jurors as in the Wesley Harris case, or one juror, or in my mind even three jurors, at least 3, 2, or 1 juror should not prevent a simple recommendation going to the judge in that case or any other that the death penalty shouldn't be applied in a situation like that. That's the problem in Georgia that we're attempting to solve, and that's the problem that my bill does resolve. Thank you, Mr. Chairman. We have to take any questions at this time.
Questions from the committee for Representative Fleming. Representative Benfield and then Representative Mangum.
Thank you. I'll have a microphone. Just try to speak up. Representative Fleming, you said, and I should know this because I've done some work on DNA testing, but you said that DNA testing will be used in all death penalty cases, from now on, and I understand where there is evidence that would be appropriate, but is that mandated by law anywhere, that where there is DNA evidence or where there is sufficient evidence collected to do DNA testing, that it will be done? Is that mandated by state law anywhere?
I don't know if it's mandated by state law. Mr. Chairman, I'm going to quit flipping this microphone if I can't get it one more time. I don't know how I messed it up. I don't know if it's mandated by state law, but I tell you, any DA who brought a case to a jury and the defense attorney would say, had they only done DNA testing, my client would be innocent. I guarantee that's not going to happen, and it doesn't happen in all death penalty cases today.
Representative Mangum.
My distinguished colleague, I have seen some atrocities in Georgia. I'm a native of Georgia. I was born in Georgia. I practiced law. I remember in the first part of my practice in Griffin, Georgia, had the highest rate of incarceration in the state. I understood at that time that Georgia had the highest incarceration state in the nation. And there are some problems. I saw the video that you were presenting to us today, and are you saying that it mandates that you should have the death penalty in that particular instance because is that what you were trying to say, that was irrefutable evidence?
There's no question that was irrefutable evidence that that person killed that police officer. That was never an issue in that trial. The question was, when something as awful as that happens, should we be able to apply the death penalty in Georgia? And in that case, should one juror have the ability to veto the death penalty? And my bill says no. My bill says that in a situation like that, when you have a juror that goes back and refuses to even deliberate, as I think you'll see the facts when the DA talks about that particular case, should that one juror thwart the will of the other 11 and the law of the state of Georgia by basically nullifying the law by saying, I'm not even going to consider, I'm not going to have the death penalty here. What my bill does is says you have that situation happen where 3, 2, or 1 in that case do that, then they can make a supermajority of the jury, 9, at least 9, maybe 10, maybe 11, can make a recommendation to the judge, and then he can decide, in his experience, whether or not this is an appropriate case for the death penalty.
I don't know all the issues in that particular case. You're telling me that identity was not an issue in that case. It was just simply someone that was against the death penalty.
You will hear the prosecutor, Steve Kelly, come up and talk about that case as a witness following me, and he will explain to you that no, it was drop dead guilty that guy did it. The question was the death penalty going to be applied, and one juror refused to basically deliberate.
The jury system has worked in America, worked pretty good to the detriment of so many people. I've met number 19 that was on the death penalty, that was cleared of the death penalty, and he was a young guy, and I just couldn't believe, but he said I was found guilty. And we are imperfect beings trying to meet out perfection, which we will never do.
I agree.
And if there is a jury that hears the process, there is a procedure set out, and even if you want to disqualify a juror for cause, there is a procedure to do that right now.
Yes.
And if you want to make that even stronger, I would even be in favor of doing that. But once you have allowed a juror to have a vote, that juror should not have a vote that is less than any other juror. Or you should move to strike if you found some type of prejudice. But if you found a prejudice at a certain, basically what you're now saying is you picked a jury, but now you want to say that this person should have not been picked, should not have, this person should be disqualified because that person has a prejudice. Because after hearing all this evidence, they don't see it the way you see it, basically.
Let me tell you why I disagree with what you're saying. I see, and this is what I hear you promoting. You're promoting that 11 jurors' votes should be nullified by one who refuses to debate the issue, or in this case, looks at evidence like that and said we should not apply the death penalty. Right now, when you go through the jury selection process, and this is a debate that went on at subcommittee yesterday, are these people out and out lying and committing perjury, which would be very hard to prove if they were, but are they lying, or do they get into the jury box and say, you know what, I'm just not going to be for the death penalty. I don't care what the law says. I don't care what the facts are in this case. I'm just not going to vote for the death penalty. Now, whether they're lying or they get in there and they change their mind, my point is to not make it absolute. That one person can veto 11 other jurors' vote, which is what you're proposing from what you're saying.
Yes,
I'm simply saying that allow then that decision, if it's 11-1, 10-2, or 9-3, to go to the judge for the final decision.
Well, I guess we do have a philosophical difference, and I understand that that's why we have this whole system, because that's part of the process. You see it one way, and I may say it a different way, but I am clear now that you're basically saying after you have qualified someone as a juror,
Yes.
you are now wanting to disqualify them because
No,
they're not
they still get to be a juror and they still get to vote like everybody else, but they don't have a veto any longer. The supermajority can make a recommendation to the judge. A very small minority cannot veto the death penalty in the state of Georgia.
Well, let me understand something. Whereas in all other cases where death is not the ultimate decision, are you going to now say that where there are 11 jurors in a civil case just dealing with money, that I can recommend to the judge, we all want to have an award of $1 million, but this one person only wants to give $500,000. Judge, can you order $1 million at your discretion because we're tired, we've been here for a whole day, we want to go home, and this person's not moving?
I see your question. I see your question, and no, my bill only strictly deals with the death penalty. It does not deal with any other cases, whether civil or criminal, in our legal system. But think about the example you just gave me. In our civil system, if a jury goes too far or not far enough, the judge has the ability to order a new trial. The judge has the ability to do things. Appellate courts can strike down a crazy runaway jury verdict. There are limitations built into our system right now to solve that problem. If one juror votes to nullify the death penalty in a case even as awful as the one that you saw, there's really no recourse practically. My bill would provide recourse in that situation so that the decision then, if a supermajority said yes, it could at least be a recommendation to the judge and he could have the final say-so.
Well, Mr. Author of this bill, would an alternative be that you give the judge if the jury did, in your instance, have 11 persons say this person should die because this person is guilty, and one person said this person should not die, would an alternative be that there be a new trial in that situation as you have just offered for a civil where it's just a matter of money and not a person's life?
If there is reason,
life?
yes. If there's reason for the judge to order a new trial, yes, it possibly could be for some reason. And all those are motions that are debated ad nauseum after a death penalty trial. Whenever there's a capital punishment issue, those do come up.
No.
But if you're asking, am I willing to try to think of another way to solve the current problem? I am. But I tell you that I started on this 3 years ago, and have talked to both sides, different groups. I introduced it 2 years ago, let it set so people could simmer on it and talk about it a while. This is the one way to solve the problem that I see, and I do not see a better way to do that.
In the instance that I gave you, that we're dealing with simple money, where money's money, and you can get more money, but you can't get another sacred life is important in society. And what I want to suggest is, if 11 jurors said he should have the death, and one juror said no, would you be willing to say that would be grounds for a new trial in that instance, similar to what you just stated for an issue where there was a deadlock over mere money?
No, and I didn't say that about mere money in civil cases. I just said there are other ways you can address that. But my point was, in a criminal case, you never can go back and ask for the death penalty again, unless for some other reason there was a new trial ordered. Here's my point. If 9 jurors, a supermajority, say that this was so heinous and awful that the death penalty should be applied, then they can make a recommendation, 9, 10, or 11 can make a recommendation to the judge that the death penalty be applied. And it's actually, in concept, not that complicated. And it is a solution to a real problem that I think exists. And we're not the only state to do this. Other states have done it.
I am simply asking you whether or not you would be willing to make it law that you could have a new trial, that you could ask for the death penalty again with another jury, a separate whole group of persons, to put someone to death, whereby there will not be the arrangement where you have the one person as you are
if I was an advocate of abolishing the death penalty, I might think about what you're doing, because I think you would throw such a monkey wrench into the system by doing that you probably would top death penalty cases in Georgia for a long time. So no, I would not agree to that.
Representative Byrd waves off, Representative Abrams, and then Chairman Knox.
You got my copies?
I have a couple of questions. Going back to your...
Oh, they'll have them. I apologize.
No problem. Going back to your comment about DNA evidence being available, do you have any statistics on the number of death penalty convictions in the state of Georgia that were based solely or primarily on eyewitness testimony and not on DNA testimony?
I do not, but my suspicion would be there were some.
And with this bill, it would be my reading that this bill would permit the death penalty to be imposed by less than by 9 persons, or be recommended by 9 persons, even though there is even if they don't have access to DNA evidence. It's purely based on what we have in Georgia recently acknowledged to be a somewhat flawed eyewitness testimony system.
You realize in what you just saw there were no eyewitnesses. No human being could testify in trial that officer got shot in the head by that guy he stopped. Yet there was good evidence. So my point to you is this: you're trying to say that we should eliminate in any eyewitnesses cases, or you're heading that way in a death penalty, and I would say absolutely not, because there are times when eyewitnesses are irrefutable good evidence that a murder did take place. And once again, I remind you, 12 jurors still have to unanimously agree that in fact that is the person that did it before you even get to the question of death. So I disagree with your premise.
Well, sir, I mean, my premise was not what you reached. I'm simply asking a question. I would speak to the Pete Williams case, where we had an eyewitness who was the reason for conviction. 12 people voted in favor of that conviction. My concern is that DNA testimony is not always available. It is not always positive, and that you do have cases where we can impose the death penalty, or we can certainly find guilt where there's eyewitness testimony, which I think there's ample evidence to demonstrate this is not irrefutable. So that would be my first question.
Let me answer that again, because I'll give you the same one I gave you last time. Your point is that eyewitness testimony is not good enough to imply the death penalty, in your opinion, in some cases. I would say you're right, and that's when a juror of 12 says no. But if in the penalty phase, if after 12 did say yes, this person did it, in the penalty phase, then if they're not unanimous, then the judge gets to have a call on that too. So and not only that, but as we know, the appeals that go on after death penalty case has been successfully implied go on forever. And there's chances for all these issues that you're talking about to come up, and sometimes they do, and that's why the system works.
Again, I would refrain from, I'm not trying to I wasn't making that statement. I'm simply asking questions. My second question actually goes to your issue of prolonged appeals. In those states that have imposed or who have permitted a lessening of the penalty, meaning that you can allow fewer than a unanimous jury verdict on the issue of the death penalty, has there been any statistical evidence about the elongation of the time that it takes to manage those appeals?
Let me grant to you this. I guarantee you that the ACLU and every other organization that wants to abolish the death penalty will use every time they can that we change the law to try to prolong the appeals process. And I guarantee you they will litigate it over this. What I would say to you is this, though. I'm not going to allow them and other people who want to change the law in Georgia to do it by the process of appealing it and by thwarting the death penalty because we passed this law. If I was not absolutely sure, if the DAs that come before you today who know this issue even better than I do, was not absolutely sure that what we're doing is constitutionally very sound, then I would not propose this bill to you. So will people opposed to the death penalty in principle try to prolong the appellate process? You are absolutely right, but they do it already, and they'll continue to do it no matter what bill we pass or don't pass.
So your answer is that you don't have evidence about how long statistics about how much longer.
No, but I'm going to guarantee you there'll be more appeals because they always do it no matter what.
Do you have any information about the cost that imposes on the state when you have the elongation of appeals and when you create a new cause of action for those appeals?
And I don't think that anybody does, but I'll guarantee you it'll be more.
Thank you.
Whichever. You ready? Chairman Knox.
Yes, sir, Mr. Chairman.
I think I should make some disclosures. I do practice criminal law on the defense side.
Sure.
I haven't prosecuted any cases yet. But that's not what my issues are about. I think it seems to me like we've fallen into two camps, one in opposition and one
one in pro death penalty, I guess, and I don't think I fit in either one of those. I've got some problems with the death penalty in certain cases, but not necessarily out of a principle. I think there are certainly cases that the death penalty is warranted. Clearly, the state has the authority to impose a death penalty, and so that's not where I am. Because I don't oppose the death penalty. I think there are some people who oppose the death penalty, though, and they're citizens of the state of Georgia who do. Clearly, the district attorneys have taken that into their calculation, and perhaps in arriving at the numbers they've come up with. Because if you figure a 9-3 verdict, that's about 30% of the population, roughly, which is about the percent of the population that you would expect in a case that would be opposed to the death penalty. My issue is more about the principle of, I guess, the jury and what their role is and their responsibility and authority is, and so when we talk about, and I've struggled with this issue about nullification of the jury, and you make a good argument, and so do others make a good argument that, in one sense, one juror can nullify the vote of the other 11 jurors. But when we do which I think is just as important, when we do the guilt or not guilty phase, which I'm going to use because innocence not really an issue in the trial. It's whether you're guilty or not guilty. And that's important because that goes to the issue of whether or not the government proves its case, not whether the person's even guilty of the offense. And that's really what's at issue in the trial. So I guess my question is this: how would you respond to the fact that in deciding whether a person even did this crime or not, that we require that every one of the jurors find that person to be guilty, and that every one of those votes is equal in the conviction phase of the trial, and that if one person votes against it, we say, and I don't think anybody wants to change this, at least I haven't heard anybody say that they want to change this, we say that one person's vote will cause that person to be free and not to suffer the consequences of the law we currently have or the law that you're proposing.
Mr. Chairman, you asked the question, thank you, that is before the committee today. Should we allow that one person, and we'll use the case of the one you just saw, should we allow one person who gets on the jury and says that they're open-minded and willing to apply the death penalty to stop the death penalty from occurring in a case like that? That is the operative question before this committee right now. I say no. I say that a supermajority of 9 should be able to recommend to the judge and then he make the final decision. But I respect and understand the question you're asking, and it is the one before the committee today.
Let me, if I may, Mr. Chairman, just follow up. Along that same line, we heard testimony from the district attorneys, not this last time, but a previous hearing we had, and I was actually surprised about the response, because I thought the argument would be that we need this law because people get on there and lie. And that's not what I heard from that district attorney, who I thought did an excellent job, probably better than anybody that's appeared before before the committee with respect to this issue. And he said it's not about people getting on the jury and lying. He said, as a matter of fact, when people come to, he said, more than that, is when people come to the penalty phase, unlike the conviction phase, that they're entitled to take into consideration all of their experiences, all of their life experiences. You can even bring in your prejudices if you want to in the penalty phase. And that's because the law doesn't prevent it. It's not unlawful for me to say, you know what, I've changed my mind about whether or not the death penalty is appropriate in this case. I thought it was when I started. The law doesn't say it's unethical, it's not immoral, it's not even dishonest. According to the district attorney, he says that only about 1 or 2% of people are an issue about whether they lied on the questionnaires in the voir dire. So that being the case, if there's 30% of the people in the state of Georgia who don't agree with the death penalty in most cases, for instance, and we're assuming that all of those who are going to lie or that weren't going to be or who had some principle about death penalty and would not apply, that those have been excluded during the voir dire process, which is extensive in capital cases.
why would it be that we would not accept their judgment then in this case and make it equal to the other 9 people who were on the jury? Because if they're allowed to do that, why should we not honor their opinion, their assessment, and exercise the responsibility and the authority that we've given them as a jury?
And I appreciate your question, and the DA that you're talking about that some of the people that were on the subcommittee didn't get to hear is my district attorney, Danny Craig from Augusta, and he is the fellow that I went to early on to begin to discuss this process with. Danny is a devout Catholic, very strong in his faith, has to bring death penalty cases, and thought through everything you've just said very well. And here's what I heard him say. He said in his experience, not always there's a juror that lies through the jury process to get on there, and I would grant that doesn't always happen. There are occasions, though, where the evidence is so strong that that's probably basically what has happened, that it's, I think, almost irrefutable. The case I would go back to is, once again, the one you just saw and you'll hear about later, of the fellow that shot the police officer that stopped him. In that case, the fellow on the jury was actually an alternate. And he was not in the initial 12 that decided guilt or innocence. One of the jurors got sick in between the 2 bifurcated proceedings of the trial. He was an alternate, and he got on, and he said, I'm glad y'all didn't let me on during the guilt or innocence phase, because I don't care what the video showed. I'd let the guy off. I wouldn't have voted for guilty. And he says, I sure as heck am not going to even consider the death penalty. Now, that is a juror who, in my opinion, was not completely straightforward when he got asked that litany of long questions about whether or not he should be on a death penalty jury. You're right, the 30% of the people in Georgia who are opposed to death penalties, voices should be heard, but that process should not take place after they've gone through a jury questionnaire that's very detailed about their feelings and will they be open-minded. That process takes place where they vote to elect members to come to this legislature, and we decide for whatever reason that we don't want to have the death penalty in this state. So they should be heard, but they shouldn't be heard through a jury nullification process. They should be heard through a legislative process.
Further follow-up, Mr. Chairman? On that issue again, I don't want to beat this to death, but you and I have had
Certainly
discussions about this. I can relate to your DA's problem because I come from the same tradition. But here's a question I have. Whenever we talk about this, or when we've been talking about it, we're talking about the process of a person, a vote, or 2 or 3 votes being able to nullify the will of the jury. But we're always talking about it in context of somebody who doesn't want to impose the death penalty, those people. And our assumption is that they don't want to do that, if they don't agree with us, they shouldn't be allowed to exercise that vote. Because basically what we're saying, we're going to throw these 3 votes out, so we're not going to let them exercise their vote. My question about it is this.
I'd say they still get to vote, they just get outvoted 9-3.
Well, okay.
Yeah. All right.
Let me ask you this then. What if, just as in the guilty or innocent, guilty or not guilty phase, what if the 3 people we're talking about, instead of being wrong in not voting for the death penalty, are right? What if those 3 are right and are wrong? That can happen, does happen, it will happen under the current law or under this proposed law.
Realize what you just said, that 3 people are not wrong about guilt or innocence because they already voted on guilty. You're saying that they have a different opinion about whether or not in the facts of this case the death penalty should be applied. And once again, I think if you're going right back to the heart of the discussion that is before the committee today, should we allow 3 people who, after all that procedure, have decided in a heinous case they don't want to apply the death penalty, should they, 2, 3, or 1 have a veto over it? I say no. I say let the supermajority give a recommendation to the judge.
I guess my issue was more about, and I may be wrong about the presumptive capital cases, I'll stand to be corrected on it, and you can correct me if you know a different thing. The 3 people may discover, based on the evidence that's presented in the phase where we talk about the aggravation of circumstances, where we say that this crime is so heinous that nothing but the death penalty is going to resolve it. There could be 3 people on there, could be 4 people on there who decide, I don't think it's that heinous. It was heinous.
Right.
It wasn't that heinous. It didn't meet the circumstances the judge told us that we have to meet with regard to aggravated circumstances. counsel, and that's not somebody that just doesn't that opposes the death penalty. They just don't see it in this particular case. How do we address that in this?
You address it by allowing those 3 people to go into the jury room and advocate to the other 9 jurors of why they're right. And you have the same debate in the jury room that you will have always about who is going to decide. And then you have a guy who is elected and does these cases all the time, sees death penalty cases, called the judge, who we put a tremendous amount of faith in many other situations, has to also agree that the supermajority of the death penalty should be carried out. So I think, once again, you've gone right to the heart of the debate. I phrase it as, should we allow 1, 2, or 3 people to have absolute veto? You phrase it, what if those 1, 2, or 3 people have a better argument? And under my law, they have a right to make their argument and convince the other jurors.
Thank you, Mr. Chairman.
Thank you. Yes, sir.
Representative Abrams. I'm sorry. Okay. Further questions for the author?
Mr. Chairman, if there are no further questions, the one thing I would point out to you that I didn't mention earlier is it passed out to you, and of course all the subcommittee members saw this, is a letter from the Attorney General of our state, Thurber Baker, supporting my bill in its current form in support of the death penalty.
Okay. I'm going to look to you to sort of give me or give me your preference on organizing the presentation on behalf of the proponents of this bill.
Yes, sir.
I would ask you to be mindful of the fact that the subcommittee spent 5 to 6 hours on the bill yesterday, and we also want to hear in a fair way from those who oppose the bill. So, having said that, tell me how you'd like to handle that.
Mr. Chairman, for the proponents of the bill, what I would recommend to you, and I've already discussed them, what you just said about having it briefer than it was yesterday, I would ask first if Mr. Danny Porter could come up and tell you about the Harris case. That is the case that had got a lot of attention just recently in this. And then there are 2 other DAs that I would come up after that. Okay.
Mr. Chairman, while I'm leaving, are there any empirical data one way or the other regarding the average juror in Georgia or anywhere else?
I think that was a question for you.
You will hear today from several district attorneys and several opponents of it, different statistics that say how often this may or may not happen. It's a matter of opinion as to which of those statistics are right or wrong. But all I can say to you is that there definitely are cases where it occurs. It's probably occurred places, times that we don't know about. So is there one sheet that tells you how many times this has occurred? No, I don't think there is. But we know it's happened.
District Attorney Porter, Gwinnett County.
Thank you, Mr. Chairman and members of the committee. I'm going to be brief, but I would like to very briefly recap the facts of the state of Georgia versus Wesley Harris, and then the procedural history that led us to this point and got Representative Fleming interested in the case. On November the 8th of 1999, Wesley Harris carjacked and kidnapped I have to remember the names. I've just drawn a blank. But Whitney and Jordan Land. They were residents of Clayton County. They were in a park in Clayton County. She had taken her daughter there Whitney had taken her daughter Jordan there to take some pictures and to play in the park. And at some point they were, we believe, carjacked by Wesley Harris, kidnapped and taken to Gwinnett County, where they were both executed. The physical evidence in the case showed that Whitney had been more than likely shot while in Clayton County, but survived into Gwinnett County because her cell phone recorded 2 sequential 911 calls that were interrupted, and then finally the cell phone was quiet. At that point, they were taken to a dirt road by a water treatment plant. Whitney was probably removed from the vehicle and shot twice in the chest, dying there. Jordan never left her car seat. She was shot in the car seat, first in the chest, and second, the fatal wound was to her face. Just so you have some perspective, this is Whitney and Jordan Land in life before the kidnapping. This is Jordan in a close-up that was provided by her grandmother. I really can't show you the pictures of what they look like afterwards. It wouldn't be suitable, because Wesley Harris then took the bodies, put them in the trunk of the car, and burned the car, and fled with a friend, disposing of all the evidence. We actually tracked Wesley Harris through the use of the cell phone. From the cell phone, we were able to find out the people who helped him dispose of the evidence, and they implicated him in the murder. And from there, we were able to construct a case that led to a verdict of guilty. You're going to hear other DAs talk about jury selection, and I can tell you I believe that I probably hold the record in this case for jury selection. We were in jury selection for 7 weeks. I told somebody if there's a ninth circle of hell, I visited it, and it was during the jury selection of this case. We extensively interviewed over 200 witnesses, taking about an average of an hour a person. That's in addition to a 19-page jury questionnaire that they filled out under oath, asking them everything from their favorite radio station to what books they read to their feelings on the death penalty. We, in due course, selected the jury and tried the case for approximately 2.5 weeks. The jury got the case, as in all death penalty cases, first to determine the guilt or innocence of Wesley Harris, and that is a requirement of a unanimous verdict. Had there not been a unanimous verdict at that point, there would have been a mistrial, and we would have started over, which is normal in criminal cases. But there was a unanimous verdict, not only for both murders of Whitney and Jordan, but also for armed robbery, carjacking, kidnapping, and other capital felonies. There were almost 9 aggravating circumstances in this case that were alleged by the state. At that point, we moved into the penalty phase of the trial. Evidence was presented by the state that Wesley Harris had tried to escape at least once from the Gwinnett County Jail, and he had been involved in at least 3 prior incidences with police involving drug usage and firearm possession. The jury heard that evidence from the state, and then the defense presented mitigation evidence regarding Wesley Harris's background. There was no evidence of mental retardation. There was no evidence of injury or organic brain defect. There was no incidence of child abuse. It was basically that Wesley had a normal childhood, grew up, and in fact most of his relatives didn't understand why he was even there or what led him to this. After hearing all of the evidence, the jury went back to deliberate and unanimously found all 9 aggravating circumstances. And then, from that point, as in all death penalty cases, the case moved to the actual consideration of punishment, which you've already heard from Representative Fleming, is a totally discretionary decision with the jury. Once they found the aggravating circumstances, and in answer to your question, if it was 11-1 for the, or I believe it was Chairman Knox's, if it was 11-1 not finding the aggravating circumstances, death would not even be on the table. If they don't find the aggravating circumstance, there's no possibility of death. But once that happens, they can consider. We had one juror who participated in the and we heard testimony yesterday in the subcommittee that he did participate in the deliberations, but required proof of a fact that the state is not required in order to convict of murder or to prove a statutory aggravating circumstance. One juror who during jury selection asked to be excused for financial hardship. She also asked to be excused because her daughter was going to have a child. And I agreed to that excusal at her request, but the defense kept her for reasons that had nothing to do with her qualifications. She refused to participate in the penalty deliberations. Not that she reached a decision that the death penalty was not appropriate. Not that she believed that the death penalty wasn't justified in this case, but that she wouldn't participate. The other jurors have since told me that they believe that they could have engaged in a dialogue with the juror who participated but held the state to a different standard. And had that happened and this case came out 11-1, you wouldn't see me sitting here today. But when a juror refuses to participate in the process, thereby ending the case, because there are no mistrials in penalty phases of death penalty cases. The law as it is today is that one juror can make the decision, and that decision is binding, and there's no appeal by the state, And there's no choice for the judge other than to enter a sentence of life without parole or life with parole based on that majority. But that juror ended that case. And that case came back, and Wesley Harris was sentenced to life without the possibility of parole. The question came up yesterday of why are we doing this? And my answer is that despite reservations about judges that were expressed by the defense bar, despite a lack of trust of judges that was expressed by the defense bar, I happen to trust judges. And I believe that judges can make decisions, and in fact will make decisions, regardless of the political popularity of that decision. I believe that in order to add more security to the system, add more unity to the system, that in the case where jurors cannot reach a decision, it should be turned over to a judge for review. And that judge would then have the option to enter any sentence that was chosen. And I believe that's the reason that this committee should pass this bill. It has nothing to do with, and in fact, looking across my bench last night, the bench that sits in Gwinnett, I can tell you with great confidence that there are judges there who, if a jury recommended 9-3 that a person get death, and that judge did not believe that this case was justified for death, they would impose a sentence other than death. I believe that there are judges that I would argue with of whether that case deserved a death sentence, and because of their beliefs, they wouldn't give death. And I think there are those judges across the state. And I think that's the reason we do this in those cases where juries are unable to reach verdicts. Not in the cases where a jury unanimously votes for life or unanimously votes for death. Yesterday, the subcommittee heard testimony from Mrs. Howell, who was the mother of Whitney Land and the grandmother of Jordan Land. And I think it would be fair to say that this jury got some idea, or this committee got some idea, or those of you who were present got some idea of the sense of loss that she had by these two murders. I think you got some idea of the sense of loss by the existence of the veto power of these two jurors over what she considered to be a just result. And I think that you got some idea that that sense of frustration and that sense of loss was magnified, not so much by the one juror who appeared before the committee. I think she can live with that. But the juror who in my opinion, misled both sides, both the defense and the prosecution, and then made an arbitrary decision not to participate, just not to become part of the process, combined with the jury's lack of knowledge about their remedies, whether or not they could have that juror removed, I think she felt like that justice was snatched from her. And that was reinforced by the juror, one of the jurors who voted for the death penalty, Miss Denise Schneiders, who came in. She's a teacher in Gwinnett County. She teaches her kids about civic duty, and she did her civic duty. And she came and she listened to the evidence and she voted. She participated and voted. And I think her frustration is that her vote was nullified, not by a vote, not by a person who participated, but by a person who refused to participate. And I think that's really what we're here about, or at least my perception of it is. I agree with Mr. Craig. He's a lot smarter than I am. And I have not had tremendous experience with people who have lied to get on juries. I have had one that I discussed with the subcommittee yesterday, that I believe that person misled the questioners and did in fact have an agenda to get on the jury. But in this case, I'm not so sure, except that I think that what we were left with was a juror who was unwilling to continue, who was unwilling to participate, and the remedy was not available to them. The option was not available to them, or made available to them. And I think at that point, judicial review is necessary. And that's why I'm here in support of this bill.
Representative Abrams.
Thank you, sir, for your testimony. I have two questions. Just as a matter of principle, do you believe that there's information that can be presented in the penalty phase to mitigate the imposition of the death penalty after a unanimous jury verdict has been issued?
You have to, if I could explain the procedure, is that if you're talking about a unanimous verdict as to guilt or innocence, then the answer to your question is yes, because the first decision the jury makes and has to make unanimously is whether or not the defendant is guilty or not guilty. Okay. If they've made the guilt decision unanimously, then certainly. I've had cases. In 1995, I tried a police officer in Gwinnett County for murder and sought the death penalty. If you were to ask me today, does that police officer deserve the death penalty for murder and armed robbery, I'll tell you yes. I'll look you in the eye and tell you yes. The jury said no. In fact, it was 10-2 for life. And that was solely based on the testimony of his father, who said that Mike was a better father to his children than he was to Mike, that his brother, who was in law enforcement, his family, who talked about his children, and in fact, when I talked to the jurors later, they said that they were not prepared to vote for death because they didn't want his children to go through that. And they actually voted for life. Mr. Munford and I tried a case exactly the same where we each received life sentences, despite a case that to this day I believe he thinks justified the death penalty. So yes, I've had mitigation evidence that convinces jurors to vote unanimously for life.
My question is because I understand and certainly do sympathize with the concern about aberrant jurors. My concern is that this is an overreach, that instead of addressing a very specific issue of dealing with aberrant jurors in the penalty phase, we instead are approaching weakening centuries of jurisprudence and removing unanimity, which is one of, I think, the hallmarks of our system. And I would certainly be persuaded that, I may be persuadable that on the issue of having judges be able to intervene in the deliberation stage and remove jurors for cause for failure to participate, that to me is a much more persuasive argument than is one that says that unless you have that permits 3 people or that will permit 9 people to ignore mitigation evidence as people. My concern is that mitigation evidence has constantly been shown to be a necessary component to adjudication, and that where we are now to answer your issue could be answered by dealing with jurors in the deliberation stage as opposed to completely altering and changing the fundamental structure of our jurisprudence.
I would only have 2 answers to that. Is one, I don't believe that the bill calls on anyone to ignore mitigation evidence, because it allows, first of all, for a unanimous verdict of a sentence less than death. And it only allows for a supermajority of 9 votes for death before the judge even gets involved. And there's precedent for that now. Right now, we have statutes in place that allow for judicial intervention in the event of a split penalty verdict. Even now, what we have now is if I'm working strictly from memory, so you might have to have legislative counsel look this up. But if a majority of, I believe it's 7 or, excuse me, Mr. McDade, it's a majority of, that's 7 votes. If there are 7 votes for death amongst a jury now, then the judge is authorized to intervene, take that case from the jury, and impose a sentence of life without parole. Even if there are 7 votes for death and 6 votes for life, the judge is now authorized to sentence to life without parole. In a hypothetical case, that might not even be on the table. So we've already allowed judicial intervention in the event of a non-penalty verdict. But this bill authorizes the judge the option of sentencing to death if there are 9 for death.
Can I put you on the spot and ask you to articulate why? I mean, I think there certainly is an underlying reason why you would allow judicial intervention in non-death penalty to impose a sentence less than death versus allowing judicial intervention to impose a sentence that is death. Do you see do you see a distinction between those two penalties?
There was a lot of talk yesterday that death is different, and in some circumstances it is, but in many instances it's not. In terms of the rules of evidence, in terms of the way the case is tried, in terms of the procedure of the case, a death penalty case is very similar to every other criminal trial. So I think the difference would depend on your perspective in some ways about the death penalty itself. If you have support, if you support the death penalty as an appropriate punishment for certain crimes, which I do, then you can recognize that procedure is a logical extension of what we allow our judges to do now. That to give the judge the option for death is another sentencing option that judge finds. And I guess I go back to what my testimony was yesterday, is that we trust judges with a lot of things in our system. We trust them with our kids, we trust them with our money, we trust them with our property, we trust them with our marriages, we trust them to sentence people. We've taken jury sentencing away. So I think it's a matter of how you feel about the death penalty in terms of the logic of the next step of giving them the option.
I have one final question.
Sure.
As a finite point, do you believe that if you solve the issue of deliberation, where the judge had the ability to intervene in deliberation and remove an aberrant juror or a maverick juror, would that have resolved the issue that you faced with the Wesley Harris case?
I don't know. I honestly don't know the answer to that, because the first thought that comes to my mind is, how do we define the aberrant juror?
I mean, I would say that you spoke of, your evidence was that this person refused to participate in deliberation. If you have a person who refuses to participate in deliberation, and the jury foreman, let's say, unless it's a jury foreman, in which case it would have to be the second, if that person is willing to provide information to the judge saying that this person is refusing to participate in deliberation, please have this person removed for cause, would that have solved, if that were a permissible action, would that have resolved the issue that you faced in the Wesley Harris case?
It might have solved it in that case, but it won't solve it for the juror in the second example that I gave to the subcommittee, who basically assured everyone that they could consider the death penalty and got into the jury room and said, no, I'll never vote for the death penalty. I don't care what they say.
Thank you.
Representative Bingham.
My question was asked in that last exchange pretty much. So I guess I understood your answer, and that is it would resolve the one case where the juror refuses to participate if the judge was allowed to disqualify the juror and replace that juror for purposes of the sentencing phase. But in the case of a person who is shown to have lied, basically is what you're saying.
Well, I hesitate to characterize it as a lie. It may be more characterized as cold feet. Is that where that juror has assured both of the questioners that they can carry through with their duty, that at some point they back away. They can't do it. And that the examples that were given, and I think will be given by other DAs, sort of illustrate that point. Although I admit there are some that have we're going to have to recognize there are people, for whatever reason, do lie about their feelings about the death penalty to get on these jurors for the purpose of, and I'm not saying they don't lie in the other direction, but we're not addressing it.
Well, in the instance where a person gets cold feet, essentially under this particular bill, we're basically going to nullify their vote. In fact, we're nullifying 3 votes, or 2 votes,
Or 1 vote.
or 1 vote. In those instances where you quote unquote have gotten cold feet when you believe the evidence. There is no mitigating evidence. And if they are not considering something in their personal experience that would mitigate the circumstance, basically is what you're basically coming to the conclusion. Or am I wrong about that understanding?
Well, I Representative Mangum, I think it would be better perhaps to listen to one of the other DAs who has an example of what I would describe as cold feet, which was referenced by Representative Fleming, who said that the alternate juror came in and said, I would have never voted guilty, and I'm never going to vote for the death penalty. That's moral, and then refused to participate. That's a very difficult juror to disqualify for cause. We've been throwing around these answers. Well, you can just take them out for cause if they don't participate. That's really much more difficult than it seems, particularly since oftentimes there's not clear evidence of the juror doesn't stand there and go, I'm going to sit in the corner, I'm not going to talk to y'all. It happens differently.
But you've just given the testimony that someone said, I'm not going to vote for the death penalty under any circumstance.
Mm-hmm. Which is
my understanding. You just said that.
I believe that's the facts in the case that was referenced by Representative Fleming, and in that case, that would be an abrogation of that juror's oath.
And what I'm suggesting is, are you willing to, under those circumstances, have the judge to disqualify that type of juror and have a replacement in the sentencing phase?
Well, the answer to that question would be, I guess I'd answer that with another question, is how do you find that out without the judge unnecessarily interfering in the deliberations process? Do you have a monitor? Do you have a judge who checks in and goes, everything going okay? Are you all deliberating and participating?
I'm using the example that you just gave this time, that you just had someone to say.
But the point is that Mr. Kelly didn't find out about that till the verdict had already, till the non-unanimous verdict had already come in and the sentence had already been imposed.
I guess you're now saying that you will not be able to find out that there is an aberrant person. They'll have some reason, but you won't know the reason that they are not voting for death. But you're now saying that you will disqualify their vote and not allow someone to be replaced for that vote simply because you don't know why they are not voting the way the other 9 are voting. Is that basically what I'm hearing?
You're not basically hearing that. I'm turning it around and I'm saying that this law would allow the 9 votes, the majority, to basically override, just as the votes of this committee will make a decision about this bill. And your vote is not negated.
Well, it'll be 50. Anything over 50% a year
we're not arguing for the 50%. We're arguing for more than for the minimum of 9.
The remedy for politics is a little different. Every 4 years, we'll vote a Democrat in, a Republican in, whatever. That's the remedy. There's a remedy that the people, when George Bush went too far out there on the war, people said, come back in a little bit, George. We want to protect our country, but not under certain circumstances. We have a remedy for that. Here we are dealing with a different situation, and we're dealing with whether or not we're just going to negate the vote of 3 persons on the juror by not honoring our Constitution that says you'll have a unanimous. Does the Constitution even require unanimous?
We found out yesterday that the Georgia Constitution requires a jury of 12, but not unanimity, and the federal Constitution does not require unanimity or a jury of 12. It's a matter of tradition, and we've carried it over from the common law.
These are very sacred grounds that we are traveling on. I mean,
and I don't disagree with that. And for 25 years, I've honored that. I've been a prosecutor for 25 years, but I believe that it again, it goes back to your perspective. I've seen too many cases where the qualms seem to be that these decisions will be made by one person, the judge. Well, they're made by one person today, or two people, or three people.
You know, that's not my comment. And respectfully, if you disagree, if your answer is whatever your answer is, it is. I'm not. I mean, I'm simply asking you whether or not, under any circumstance, in your experience, which I respect, that you would honor the unanimous verdict concept by allowing the prosecutors as well as the defense to re-voir dire, re-question the juror as to the basis of their non-participation on what obviously appears to be a false representation to the court, or what appears to be a beyond question an unreasonable, aberrant holdout. Whether in those three instances, for example, that you would venture to say that the court could, this body who is charged with providing Georgia law, would remove those jurors and allow the judge to honor the unanimous verdict concept and allow the replacing those particular jurors in those circumstances where there is the circumstances I just described, or any that you can even come up with.
I'm not prepared to write legislation in the committee, given the fact that I support this bill as a solution, and I'd have to look at any other solution to see whether I could support that, because I see in your hypothetical, I see issues that immediately come to mind that I can't address in the testimony before this committee.
Well,
If you're asking me, would I agree to that in lieu of this bill, the answer to that would be no.
well, one of the problems that you do see with, basically, I may never see the light of day. I may vote against this today, but I'm trying to, I don't practice as a prosecutor. You say you see some problems with it. I'm simply asking, what are the problems?
Well, the initial problem that I would see just right off the top of my head is procedural in nature, is that you would have to define what would be a juror who would be, what are the criteria for that juror to be called out and individually questioned, and then what would be the criteria for that juror to be replaced? Is it simply that they disagree with the other jurors? I don't think that would withstand any kind of judicial scrutiny. It would have to be, we would have to set out a set of criteria that would allow for the excusal of that juror, and those may be ones that I'm not. You might have to get Danny Craig back up here to give you those ideas, because like I said, he's a lot smarter than I am.
But isn't that what we're doing? We're basically saying that these three that are holding out are not agreeing with the 9, so let's not take into consideration their vote.
Well, I think more akin to what we're doing, and more what would be along your line of practice, would be where there's a verdict not, or a motion for acquittal notwithstanding the verdict, or, and I have to remember back to my civil procedure, or a judicial reduction of a damages award. That the result is so aberrant that judicial intervention is required, and I think that's the better analogy.
So you're saying that you would go for something on that basis, not saying that I know you're for the bill. I'm trying to find another possible solution to what I am hearing is a problem. And sometimes democracy works by flushing out and debating and hearing other practical solutions to the problem. And I think I heard, and you can say you didn't say that, but I think I just heard you say that similar to the civil circumstance where you can have a motion notwithstanding the verdict, basically, you can have a motion that says, Judge, I know the jury found this way, but notwithstanding what the jury said,
I think that's what the analogy to this bill is, that when the jury can't decide, can't make their decision, then the judge will step in based on the vote of the jury. I think actually, if you look at it in some senses, this is a way, I keep going back to, this is a way of honoring the vote of the majority, or of the supermajority.
thank you.
Thank you very much, Representative Mangum. Vice Chairman Mumford.
This is going to take a while.
Will it? Okay.
I'd say 15 minutes.
Okay. Vice Chairman Munford has been kind enough to tell me he thinks his questioning will take about 15 minutes. I had hoped that before we took a lunch break we could finish with Mr. Porter, but I think that unless the committee has an objection, we're going to take that break at this time, okay? We will come back at 2:15. If I could have your attention. Let's come back to order, please. Could we please come back to order? I think where we were when we adjourned for lunch was Vice Chairman Mumford was questioning District Attorney Porter.
Thank you, Mr. Chairman. Hadn't had an opportunity to actually begin. It's great to see you again, Mr. Porter. Been in the trenches many years ago together.
Actually, we've been in this position. You called me as a witness in the case I referred to.
Oh, gosh. I don't even remember. Can you
I hope he was kind to you.
He was. The defense attorney wasn't as nice.
Could you I'm a little confused about how this is going to physically operate on the ground. Could you run through that?
Well, very similar to the current law is that the jury is allowed to deliberate after a finding of guilt and after a finding of a statutory aggravating circumstance. They have to find both of those unanimously, and then they begin to consider the penalty phase. There's a blurring of lines between the finding of the aggravating circumstance because there's not a separate proceeding.
Right. Now, mitigation is already presented before they find the aggravating circumstance?
All evidence in aggravation and mitigation is already, they're charged, and then they go out to deliver.
So they come back and say, we find the following aggravating.
They don't actually come back. They're instructed that if they don't find the aggravating circumstance, then they have to impose a sentence of life with the possibility of parole.
Okay. And this is not beyond a reasonable doubt, is it?
The penalty phase?
Right.
Oh, the law is sort of unclear of that. The aggravating circumstance has to be proven beyond a reasonable doubt, but mitigating evidence can be presented in any form or fashion, and there is no standard of evidence for mitigation.
So in order to find mitigation, you don't have to find mitigation beyond a reasonable doubt?
No, you can find it
this
for any
bill wouldn't
reason.
change that aspect of the law?
This bill does not change that.
All right. Then explain again now. We've gotten to a situation where they've been out and they come back and, you know, the ones I've always seen, they say, I don't know, we're having different, you know, you've seen a million of those names.
Right. That's normally how it happens, is the jury foreperson will send a note that says we can't reach a decision, we can't reach a verdict. It could be communicated to a bailiff, but somehow it's communicated to the court.
All right. Now, we have at that point the Allen charge available.
We do not have under Laguerre versus the state. Right. We don't have an Allen charge in a death penalty phase.
do you have it in the guilt innocence phase?
You can have the Allen charge, or it's a charge that says every juror must reach a verdict. You're as good a juror as anybody. It's called the dynamite charge, and it is available in the guilt innocence phase, but not in the penalty phase.
All right. So in this penalty phase, they've sent out a note and they said we can't reach a verdict. What's going to happen next?
At that point, it depends on the judge, but the law contemplates that the judge would bring the foreperson in and inquire as to
by themselves.
Generally, that's brought in just the foreperson into open court, and the judge then inquires as to the split and what of the last vote, and how many were for each of the penalties, and that's contemplated under current law and would not change by this.
So the foreman would then tell what the split was,
and how many were in favor of death, how many were in favor of the other penalty.
Would that happen right off the bat, that they would go into the death-life inquiry, or would the first inquiry just to be what the split is?
The inquiry, I believe the correct inquiry would actually be, has there been a finding of an aggravating circumstance? And then the inquiry would be, what is the split? And then the third inquiry would be, what are the votes for each of the penalties?
All right. So in our scenario, in order to reach our bill here, the jury foreman says we have found an aggravating circumstance.
Correct.
Yes. All right. And
then the foreman would report that the vote is 9-3 in favor of death. Mm-hmm. And if he just said the vote is 9-3, then the judge would inquire how many votes are for the death penalty, and if he reported that there were 9, the mechanism of this bill would come into play.
Okay. If he reports it's 9-3 for life, what would happen?
Nothing under this bill.
What would I mean, nothing.
Yeah, nothing under this bill. Under current,
he would be sent back in to continue to deliberate.
No, under current law, if the judge determines that they can't reach a unanimous verdict as to penalty, and the split is 9-3 in favor of life, then at that point the judge would be able to impose a sentence of life with the possibility of parole.
By law.
By law. And remember, even under this bill, even if the jury foreman reports a 9-3 in favor of death, the judge still has any one of the 3 options available to them. The judge, after considering the case, could sentence to life with the possibility of parole, life without parole, or death. There's nothing in this bill that restricts the judge's ability to sentence to one of the. Once the case has been taken from the jury, he can sentence to any one of the 3 options.
Now, the 3 jurors that would be at issue when we have a 9-3 in favor of death, there would be no polling of those jurors under this bill to determine what their objection was.
No, and even in a poll of the jury, there's no polling of the jury,
right. So
or a determination of objection.
So there would be no way to determine whether A, they had lied on voir dire,
no,
B, they had a legitimate reason to, in their minds, for mitigation. The age of the defendant, he was dropped on his head when he was 3 years old.
Right.
You've seen all kinds of mitigation proposed, haven't you?
Yes. I mean, it can take any form.
Right.
One defendant said his father took him fishing too much.
Okay. And there would be no inquiry then as to what the legitimacy or illegitimacy of the 3 jurors was. There wouldn't be under this bill, and there isn't under current law. Because your juror can't impeach their verdict.
Right.
There's not a verdict in this case.
There's no inquiry into the reason for the holdout in any case, under any circumstances.
Okay. What would happen if a juror came out and said that we weren't 9-3, we were 8-4 after the fact?
I don't know the answer to that.
How would you what recording procedure would the jury foreman be required to operate in order to be absolutely certain of his count?
There's not one contemplated under the bill, and there's not one under current law where the split is contemplated. we rely on the jury foreman to come in and accurately report it. I don't know of any documentation that's required, even when there's a split under current law.
Oftentimes, jurors actually do paper ballots. You've seen those used. They can do anything they want, right? Sometimes there's a tally kept on a pad of paper.
There is, and I suspect that, to answer your previous question, that it would be very similar to death penalty litigation now, where jurors years later are asked to go back and sign affidavits that they didn't understand their verdict, that really wasn't their verdict, that there's been a mistake, and it would be the subject of habeas corpus litigation.
Right. And that prolongs the death penalty, does it not?
Habeas corpus litigation? Yes, it does.
All right. That brings me to another one of my concerns. I've been very carefully studying Thurbert Baker's letter of February the 16th, 2007. I think you're familiar with that letter?
I know of it. I have not seen it.
Well, the part that concerns me, I want to read to you. It's on the last page. It says, and it's addressed to the author of the bill. It says, I know you will agree that in addressing one concern, we must be careful not to unnecessarily create other concerns that might make the imposition of the death penalty in appropriate cases even more difficult. With that caveat in mind, I fully support efforts to address the aberrant juror problem, quote, described above. My concern is that this letter may in fact be indicating that Mr. Baker thinks that in fact this new procedure would do just what he says. It would unnecessarily create other concerns that might make the imposition of the death penalty in appropriate cases even more difficult.
You'd have to ask Mr. Baker what he meant by that.
You would agree with me. You've done, I know, what, 10, 15 death penalty cases? 15. It was just a wild guess. But, it is certainly not unusual in voir dire or after a verdict to talk to jurors who indicate that they have had a prejudice one way or the other. Wouldn't you agree? And sometimes jurors come in and say, look, this guy wouldn't be here if he's not guilty.
Yeah, well, I was going to ask you to define prejudice. Yeah. It's very common to have jurors talk about their feelings about the law enforcement, or if he just what you said, if he wasn't charged, he wouldn't be guilty.
That it takes a while to explain to them that they're supposed to make certain decisions. My point is that it's not unusual to have jurors who are often prejudiced against the defendant. That if he committed a murder, then he should get the death penalty. That's their.
Well, if a juror said that during the voir dire process, they would be removed for cause. If
they lied, they wouldn't be removed, would they? Even though that was their real opinion.
I have to give you the lawyer's answer. It depends. It depends on the skill of the questioning of the people who asked.
Right. Now, jury deliberations in this state have always been secret. And a jury cannot impeach its own, or a juror cannot impeach his own verdict. Is that correct?
It's correct, except in the case in habeas litigation where they're asked to go back and question their own verdict.
All right. And in some of this habeas litigation, and in the litigation that would likely be spawned if we adopt this particular piece of legislation, we are going to be inquiring and using hearsay and testimony from the jurors themselves to make determinations about who or what thought or said what in the jury room, are we not?
I think only to the extent to determine what their vote was in the jury room. Their motivations or reasoning would probably not be a proper subject of inquiry.
So you don't think that we would be looking into the conscience of the individual juror?
I don't believe so. I think we'd just look at the end result.
Doesn't this bill necessarily devalue the view of the minority that might have found for mitigation? And it tends to give value to those who did not find reason to, or found reason to give the death penalty, but it tends to devalue those 3 out of the 12 who found some reason for mitigation.
I don't think it makes a value judgment about the vote of the minority, because
well, isn't the result that it ignores their opinion and their vote?
It also ignores the juror who will not participate. It ignores the juror who falsified to get on to the jury panel and has their own agenda. It allows that margin for the court to step in and make the rational decision.
But we all know that the jury system is not perfect. Never said that it was.
Never said that.
But you and I would both shake hands and look each other in the eye and agree that it is the best system ever devised in the history of humankind for making these sorts of decisions.
I would say that, yes.
It can make mistakes, can it?
And has.
It makes mistakes both ways.
It has.
You have been on the receiving end. You and I were on the receiving end of one of the most heinous crimes in the world. The jury just came back and said, we're not giving her the death penalty.
Correct.
And then there are cases where people who perhaps should have gotten the death penalty didn't.
Absolutely, there are cases that should have gotten the death penalty that didn't.
And that's just part of the general way our system has worked here in the United States for many, many years, isn't it?
Correct, and that's what this.
Was it truly Jefferson that said that 100 guilty men should go free rather than one innocent man be convicted?
I don't believe he said it originally, but he may have said it.
I don't have any other questions. Thank you.
Thank you.
Chairman Knox.
Thank you, Mr. Chairman. I don't know the answer to this. Why I'm asking. Where did this notion of this bifurcation in Georgia of the sentencing and the guilt or not guilt?
It essentially arose out of the case of Gregg versus Georgia that required a statutory scheme that separated murders from death penalty eligible murders and required an additional fact finding by the fact finder, which is generally a jury but can be a judge, to determine whether or not the aggravating circumstance exists. Independent of the guilt. Well, not independent, because you can use the evidence of guilt as evidence of the aggravated.
Georgia Supreme Court or the United States Supreme Court?
Gregg versus Georgia is the United States Supreme Court.
What is the safeguard that it provides? If I have the same people who decided the guilt or innocence, guilt or not guilty phase, deciding whether or not to give the death penalty or not, or some other penalty, what's the safeguard that I see there with those people?
The only thing that I can answer to that is that the United States Supreme Court has upheld that system, and even though defense attorneys oftentimes move for a different jury for penalty phase, they've upheld the system of the same jury deciding the fate of the defendant that decides the guilt.
But we don't know what the rationale for that is.
The rationale of the cases is that it provides sufficient safeguards of the due process rights of the defendant.
Some states don't do that, and their cases, their scheme still passes constitutional muster and due process. Correct?
In every state, there has to be a finding of aggravation in addition to the guilt of the defendant before the death penalty is eligible. In some states, the judge makes that finding after the jury verdict. In some states, in 2 states, the jury makes the recommendation and the judge can either follow it or not. And in other states, I believe Mr. Adams used a statistic yesterday, in a large number of states, and I don't recall the exact number, the jury makes the additional decision.
If I may, Mr. Chairman.
Sure.
Now, I may have asked somebody this before, but what's the difference between, or let me ask it this way. Why would we, in a murder case, in a capital case, you've asked for the death penalty, even under this scheme, well, I think what we're moving towards is a lesser standard. You might argue with that, whether it's a lesser standard. I think it's a lesser standard if you have to have less than unanimous verdict. Would you agree or disagree with that?
I would disagree with that because the standards remain the same as to guilt or innocence and the reasonable and beyond a reasonable doubt as to the aggravating circumstance. Because beyond that, even in the system we have now, we really have no standards. So there's no standard at all for the jury's decision about punishment once they found the aggravating circumstance. So I think we could argue, and I would say that by not requiring jury unanimity, we don't change the standard as to punishment alone.
Okay. So if I hear you correctly, what you're saying is there is no standard for determining whether or not someone should be subject to the death penalty or not.
Only the standard of beyond a reasonable doubt for guilt for the appropriate crime, and standard of doubt or beyond a reasonable doubt for the existence of the aggravator. Beyond that, the jury can decide they don't want to put the person to death because they have red hair. It's that it can be that capricious.
That's the basis of your argument that this is not a lessening of a change in standard because of requiring less than the unanimous verdict of the jury, right?
With the addition of the judicial oversight.
Okay, but let me ask you this: but for the fact that we can impose the death penalty in this case, there's no. The real issue is whether you're going to be sentenced to death or you're going to have some other sentence. The guilty and not guilty phase of trial is almost not as important.
In the vast
most cases, if I'm just correct me if I'm wrong. Maybe in most cases, not. In a lot of cases, we don't even. The litigation is not even about whether the person is guilty or not. For instance, the one we saw where the guy shot the officer, terrible case. I don't know what the circumstance of that case was, but my guess is probably we're not arguing about whether he did or not. We're arguing about what his sentence is going to be. In those cases, the sentence is a more important phase than the actual trial is of the guilty, not guilty phase. Would you agree?
Oftentimes that's true. I can tell you in the Wesley Harris case, there was a battle over guilt or innocence, primarily on the issue of not whether the crime occurred, but where it occurred. And we had to prove circumstantially that it occurred in Gwinnett County. So in a lot of these cases, there are issues regarding guilt or innocence. But I would agree with your basic premise that most prosecutors don't seek the death penalty in cases that they think they will lose the guilt-innocence phase.
And by the same token, the defense probably is working more on the issue of whether they're guilty, whether they're going to be, what sentence is going to be imposed, and whether they're actually guilty or not.
Never having been a defense attorney, I would think that they would work equally, but I don't know that.
Some probably don't justify much effort as others on that issue.
I think that's possible.
I mean, for instance, there's cases, we've all seen it happen on TV. We know that, you're not going to get a not guilty verdict on that, probably is the case, and the issue may be. Which I guess that's why I come to this question of why would we not want a unanimous verdict on that issue, which is more important than the actual guilt or not guilt. We know that. We're going to prove that. Would it be fair to ask you what your record is on the 15 cases?
I've put 5 people on death row.
Okay, and you got guilty verdicts on the rest of them?
Correct.
Okay. Isn't the case, though, that when you get that far along the process, the likelihood of you being found not guilty is pretty slim?
I don't have the numbers, but I would say in the vast majority of cases where the death penalty is sought, a guilty verdict is returned. I can tell you in Gwinnett County, my predecessor had a not guilty verdict in a case in which he was seeking the death penalty, but you don't see it very often. But to answer, I think, your question, it goes back to my statement about the reason that we're here to talk about judicial oversight for those cases where the jury can't reach a verdict. Right now, if the jury can't reach a verdict, the minority absolutely controls, because if you have one that says no death penalty, there's no death penalty. So the minority absolutely controls. We have less than a majority that deals with the case, and that goes back to my statement about basically there are no standards when we get to the decision about punishment. The standards have to be met prior to that.
Mr. Chairman, two follow-up questions.
Sure.
George, that same point. Under this bill, and I may have misunderstood what Representative Munford was asking. Is there a change in the character or the nature of what we consider under the current law the recommendation of the jury with respect to the imposition of the penalty?
Not for unanimous juries. A unanimous jury verdict as to any of the three penalties would be binding on the judge, and it does not change. What it does is basically it gives the judge the option of death, and we already have under current law in non-unanimous jury verdicts the option for the judge can impose life or life without parole.
But it will change it with respect to non-unanimous juries because we're going to throw it in the judge's lap.
Correct.
At that point.
Depending on the numbers, depending on the split.
Now then, that being the case, the standard really, currently, there really is a standard, and that standard, the only standard with respect to sentencing is the unanimous verdict. Would you agree?
That's correct.
I consider that a standard. Would you?
Correct.
All right. Now, when we go to this new system, we're not going to have that standard any longer in non-unanimous verdicts. We're not going to have that standard either. Correct?
We don't have that now.
Well, what I'm saying is that don't you have to have a unanimous verdict for a penalty in Georgia currently?
No, actually, no. Well, there has to be to get the death penalty, you have to have a unanimous verdict in favor of death. But to get life without parole, you can have a split jury.
But the new law will say that if you don't, number one, you don't have to have a unanimous verdict in order to get the death penalty because we're going to ask the judge to take care of that.
Correct.
All right, now then the question becomes, what's the standard the judge is going to apply? Or is he going to apply a standard?
I would say that it's not articulated in the bill, but it would be the same standard that a juror might use.
But there's only one judge. We had 12 jurors.
But we have a judge who's heard all the evidence, who knows the law, who understands the ins and outs of death penalty law, and is capable of making that decision within that context.
One quick question.
Sure.
I guess that's gotten to my point then, because really what I think this is about counting. We're counting verdicts. We're counting votes now. We've counted them before, but now we're going to count them in a different way. We're only going to count to 9 instead of 12. And if we only count to 9, then we're going to give it to the judge, and we're only going to count to 1.
Well, respectfully, we only count to 7 now. Because if 7 vote for death, then that ups the ante. Prior to this, you only had a choice between life with parole or death. If the jury couldn't reach a verdict for any reason, the person got a life sentence. Now you have upped the ante, so that if there are 7 in favor of death, we can up the ante to life without parole, which people say is worse than death, but I guarantee you there's 120 people down on death row who would trade life without parole for death today.
Okay. Last question.
You promise?
This is his third last.
No.
Maybe I should. Let me ask you what the difference is between what have we changed? Is we're now instead of counting from 1 to 9, we're now going to count from 1 to 12. We're now going to count from 1 to 9, and number 8 becomes the only vote that really matters at that point, right?
Well, I would say just in the same philosophical idea that what we're trying to do is empower the majority, and we look at majority votes. The defense looks at minority votes, or the minority vote. I think all of the 9 votes count.
I misspoke. Because you have, it really isn't. It would be the 9th vote would really be the vote that counts. That's going to be honest. If you have under this scheme, I count from 1 to 12 right now in the current law. Under this law, I'm going to count when I count the jury. The jury counts their votes. They're going to come back now, and they're only going to count from 1 to 9. 10, 11, and 12 they can throw out. So there's only one vote that really counts in there, and that's vote number 9. That's the only vote that really counts.
I think you could look at it that way, because certainly defense attorneys now play for one vote. They play the game. That you talk to 200 jurors, they look for that one juror.
Thank you, Mr. Chairman.
Thank you. Secretary Bearden.
Mr. Porter, I want to ask you some questions I asked yesterday.
I was going to try to sit here quietly all day, but then some issues are brought up and I just can't. So I appreciate your time of sitting there. But the Constitution's been brought up a couple of times. And isn't it true under the state constitution of Georgia and the U.S. Constitution that this country is founded on, nothing in there states anything's got to be unanimous. There are some safeguards in the 6th Amendment, 14th Amendment. There's safeguards in place, but that part is not in there, is it?
There's no mention of unanimous jury verdicts in either constitution.
And isn't it true also, because I've heard some other things about every juror is very equal here in this place. But when we give one or two the power to override 10 or 11, that gives the one or two jurors a lot more power than the majority, does it not?
I would make that argument and have tried to today, yes.
And I'm just a law enforcement officer 15 years. My words won't be as eloquent as my friend Representative Mumford's. There are mistakes made. There are some mistakes that take place. There are some mistakes that take place because we are human. But we shouldn't throw everything out. We should try to improve the system. I think we're trying to improve that system today, and we have that standard to make sure we do try to get forward and improve it.
Well, I heard one of the witnesses yesterday talk about, well, that's just the way it is, and that's the way it's always been. And if you sort of took that attitude, we wouldn't have reciprocal discovery in this state. We wouldn't have equal strikes. We wouldn't have many of the things that have passed out of this legislature. Because when I started in 1981, it was trial by ambush.
And the last thing, and I'm sure I'll have to speak one more time because my good friend Jack Martin's going to bring up something about the Constitution later, and we'll discuss that. But it's very easy to pick and choose things maybe our founding fathers said in the past, instead of looking exactly what's in the content of the Constitution and see what exactly is constitutional law. Is that not true?
Sure.
Thank you for answering those questions.
Thank you. Vice Chairman Mumford.
You can take me on.
Okay. Further questions for District Attorney Porter? Thank you, Mr. District Attorney.
Thank you. Ladies and gentlemen of the committee, I would like to bring one other brief witness, and it's Ms. Sheila Howell, who is the mother of Whitney Land and the grandmother of Jordan Land.
Come around, Ms. Howell. Thank you very much for being with us today.
Thank you. I just want to start by saying that I guess you're here trying to make the law, and I'm just someone's mother and grandmother that they were murdered, and I felt like, I guess they were robbed of the verdict in their case by two jurors. And my understanding was it could have gotten down to one juror, and I think that's really hard to accept because I felt like two people decided, not 10 or 12 or whatever it takes, since you're a numbers person. But anyway, and their case is done and over with. It couldn't help me or my family or them, but I don't want anybody else to feel like this. It leaves you feeling very empty and like the system didn't work for you. And yesterday I kind of came in here, and people that listened to me, I kind of raved on and on about it, but I really don't have a lot more to say than I just really wish that you would look at it from a victim standpoint. It doesn't seem like that there's equal footing for the victims as much so as the murderers, and I just think there really needs to be a change. And the way I was raised, basically there are things that are deterrents. I think the death penalty is one of them, and I don't have to be an attorney, I don't have to be a prosecutor to figure that out, and that's just my opinion, but I beg you to change the law.
Thank you very much, Ms. Howell.
Thank you.
I don't know that there are questions. Would you answer questions if the committee
Sure.
had any? Are there any questions for Ms. Howell? Thank you very much for being with us today.
Thank you.
Mr. Whip.
Steve Kelly.
Good afternoon, ladies and gentlemen. I'm Stephen Kelly, District Attorney for the Brunswick Judicial Circuit. I was the District Attorney who showed you the film at the start of the case where y'all saw the Deputy Sheriff. The Deputy Sheriff was one Dan Jenkins, who had been previously had been Deputy Sheriff of the Year, father of 4, an excellent decorated officer. He was that night when he made that stop. He was the defendant had previously been convicted of raping a child out of Chatham County. Had been paroled from that rape of that child. Started doing armed robberies down in the Florida area, North Florida, South Georgia area. Had done several armed robberies that night when this officer pulled him over. There was 11 seconds, if you counted, that he had left in his life after he did that. The identity was not an issue. This looks a little bright, but we were able to digitally enhance this photograph and get the tag number off the car, and tons of evidence. He was caught shortly thereafter, within a day of this case. We got to trial, and the guilt innocence he was found guilty. There were several alternates. We had numerous alternates when you have these trials that last for weeks. We have many alternates. Many things happen. We end up having to, after the guilt innocence, we end up putting one of the alternates on the panel. He got in there, and I can just summarize this. I won't take long. But after this, the juror wrote me this letter. She wrote this, said this. She said, "This is to confirm that which you most likely suspect. I believe that you deserve an explanation of the failure of our jury to reach a sentencing verdict. The tears that you saw when the jurors came to the courtroom were tears of pure frustration and anger. We had cried many times for Deputy Jenkins, but at the end, the tears were because we failed." She goes on to tell me that this particular juror said that if he had been put on in the guilt innocence phase, he wouldn't even voted for guilt. And therefore, this one juror nullified this entire process. I'm here in support of House Bill 185 and ask for your vote to do pass.
Questions from the committee for Mr. Kelly. Representative Mangum. Head back over to your right, Steve.
Yes, sir.
How you doing?
Can I see that picture?
The question that was asked of your predecessor was whether or not it is possible to skillfully extract the deficient features of our less than perfect system by, for example, polling. Is there something or some reason why you could not have a polling or a inquiry as to why the holdout person or persons did not vote the way the prosecution wanted them to vote?
I personally wouldn't be in favor of that. I think the jury system is a very sacred system. I think in the sense that when jurors are back there in the jury room, they should be free to discuss their thoughts. They should be free to vote the way they want to vote. And I think if you start delving into the consciences of jurors like that, that would be very dangerous. And I don't think that would be a good way to fix the problem. I think this bill is a less intrusive way of addressing the problem, a far less intrusive way. You just say vote the way you want to vote, and as long as there's 9 people who are a majority, then we're going to let the judge decide. And I think that way you don't intrude into these jurors' conscience. You just take the raw vote and let it go with that.
So how many death cases have you prosecuted?
Well, I've been doing this a little over 20 years. I've been district attorney for 10 years, and I thought y'all were going to ask that question. I don't keep stats much as some of my other folks in there. My office has prosecuted probably 1 to maybe a half a dozen in the last 10 years.
out of that half a dozen, how many actually did you win?
We won all of them. There's two that received the death sentence.
Of the two that received the death penalty and the half a dozen that, out of the two of the half a dozen, the others received life or either life without parole?
That's correct.
So out of those other 4 cases, which were the cases you believe that they should have also died rather than gone without life parole, for example?
Are there some of those you said that
well, you were seeking the death
that should have also received the death sentence?
Right, you were seeking the death penalty, but in retrospect, were all of them, in your opinion, should they have all been executed?
I believe so. I don't just seek the death penalty just for the sake of seeking it, and you know, there are many other cases. We've had a lot of murders in our area, unfortunately, in my 5 counties. You know, and so, you know, those who I did not think the death penalty was appropriate, we usually offered a lesser plea.
Are you familiar with anyone that has been found guilty, but notwithstanding them being found guilty, were later there was some evidence to show that they were not guilty?
Not in my circuit. As my personal belief as a death penalty, I pretty much have to, the guilt innocence phase has to almost be beyond all doubt in my mind as a district attorney. If I'm going to ask a jury to put another man's life to death, I want to know absolutely that man is guilty.
Are you aware of in the last couple of weeks, a guy that was exonerated, who had been in jail, I believe, 22 years, and
I did read the paper on that.
The victim, who is very convincingly still to this day says that I believe that he was the one. What do we do in those circumstances when the DNA evidence clearly says that this isn't the guy, and for example, the eyewitness there says rather convincingly that this is the guy, and everyone believes that this is the guy, and there is a guilty verdict.
Of course, that case was tried before we had DNA evidence, so, you know, obviously if it went to trial now, if a jury was going to weigh, if DNA evidence was actually, sometimes DNA doesn't really help us that much. You understand? I mean, if a lot of times we'll have a rape case and we'll get DNA and we'll say, oh yeah, we got a great case, and the defendant comes up and says, oh, that's not an issue. We consensually had sex. So DNA is not always the all-in-all answer, but certainly if it was the all-in-all answer, you know, if a jury had the choice to believe an eyewitness versus DNA, you know, my guess is most likely they would take the DNA side.
In our technologically
the positive of the answer.
In our technologically advancing society, my question to you, rather, ma'am, and in all deference to victims of death, I mean, the lady that just came here, I feel my heart goes out to her. I mean, she lost a dear person, and she wants revenge, or she wants justice as she deems justice to be, and she has a right to want that. And just like the woman that was raped, some murder, I mean, they did eventually get the right guy, but the DNA likewise is in. I mean, would you agree that there's not always DNA evidence?
That's correct. I would agree.
But there may be a person, if this woman believed that I raped her, and she goes, and she's a beautiful woman, and everybody in here is going to believe her and not me, right? Huh? And what I guess my question is, would you agree with me that once we do execute them, we cannot correct our imperfect system.
Final.
It's pretty final, isn't it?
Yes, sir.
And would you also agree that that I have been accused, even among my colleagues in this General Assembly, who there's no malevolent, there's no evil intent. I don't take it that way, but would you believe that some people around here call me Keith Hurd more often than I can believe? And they mistake me for someone from Athens simply because I'm tall and I'm black. Would you believe that that happens to me?
I don't know because I don't know Keith. I'm not familiar, so
right.
I can't tell you a judgment on that.
But would you venture to say that you've heard someone say that someone looks like someone else?
I think the DAs in today's society feel the way I do, and that that we would not, that most DAs today do not take a death penalty case to trial on one shred of evidence alone or on one theory. I mean, it's the cases I've had have been multiple. We may have had some eyewitness testimony, but generally speaking, in my years of prosecution, I've not put a lot of weight on eyewitness testimony unless I could corroborate it. And I learned that early on in prosecuting drug cases and stuff, that I would not rely solely on identification, that I always had to have some other corroboration. And I think most DAs today would feel the same way.
Let me put you in another situation. The mayor's daughter is sitting right here. Mayor's daughter said Randall Mangum raped me on January 31st. Randall Mangum cannot give you an alibi. The mayor is over there raising hell. And the mayor is the most powerful thing in your county. Would that have any influence on whether or not you prosecute Randall Mangum?
No, sir. Absolutely not. And I can honestly tell you that I tell you, I have. That's one reason why, as district attorneys, we need to stay where I'm a judicial, independent, constitutional officer. That's the way we created our state constitution. I don't answer to anybody. I don't answer to the mayor. I don't answer to the governor of Purdue. As district attorney, I make an independent decision, and I have to lay down at night and answer for every decision I make as district attorney. And I value that judgment. I'm proud of the decisions I've made. And I've been faced with very similar situations the last 20 years, more than you like to